A young mother is killed in front of her own children, and the suspect tried to claim that she stabbed herself 14 times. We're breaking down the case with the prosecutors in the case, Randy McGinley and Lacey Majors. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Well, it didn't take a jury in Georgia very long to convict a man in the vicious killing of a young teacher and the mother of his child, and this happened right in front of her other children, too. On Friday, a jury deliberated for less than an hour in the case of Gregory Deonte Norwood. They convicted the 29-year-old of malice murder, felony murder, aggravated assault, family violence, and 5 counts of cruelty to children in the first degree. Now, according to prosecutors, Norwood got into an argument with 31-year-old Crystal Powell, the mother of his young daughter, in April of 2022 at her home in Monroe, Georgia. And also at the home that day were Crystal's 3 other children, as well as some young cousins. And they all witnessed what happened right outside the front door, therefore the cruelty to children charges. And the oldest child, an 11-year-old, reportedly called 911 when Norwood stabbed Powell 14 times and took off with the baby. This little girl thankfully was found safe with her grandmother in a nearby county, and Norwood was arrested. Investigators say they found blood on Norwood's shoes that was a DNA match to Powell. Very big piece of evidence there. But what about the defense? You got to hear this, because Norwood claimed that Powell had stabbed herself more than a dozen times. He even took the stand in his own defense during the trial. But the medical examiner said that the wounds were not self-inflicted. The children who witnessed this awful crime also testified during the trial about what they saw. And after the jury returned its guilty verdict, the judge sentenced Norwood to life in prison without the possibility of parole, plus another 100 years. Joining us to talk about this are District Attorney Randy McGinley and Assistant District Attorney Lacey Majors from the Alcovy Judicial District. Thank you both so much for coming on here, and congratulations on winning this case. Immediate reaction, how do you feel about it?
It was a long week, but it was also a really long 2-year process. So I feel good that there's been some justice, but it was emotional and exhausting, mentally, emotionally, physically. So I feel good for the family, but it's one of those things that never really feels like you win. It's just there's a result. So.
And Randy, I was going to ask you that too. I mean, your reaction to it, and also how, as Lacey said, how the family is doing right now.
Yeah, I mean, I think murder cases in general, when you handle them, they're difficult because it is, this doesn't bring back a loved one. And that's the hard part about it, is justice that's served. The families, they were there throughout the entire trial. A lot of the family showing support for Crystal, which I think was a very important thing. But it was a lot of, Miss Majors and her trial team did an amazing job and really deserve all the credit for their work along with the law enforcement. But the families, they're obviously happy with the result, but still a, bittersweet situation still, though.
No, absolutely. Of course. Were you surprised at how long the jury took to come back with the decision?
Yes and no. Yes, because it feels like such a clear-cut case, because I knew exactly what the evidence was. I have known from the beginning exactly what was going to come out in trial. But no, at the same time, there were 26 witnesses. There were 133 pieces of evidence. We were in trial for 8 hours a day for a week. I think if they hadn't taken their time and taken their job seriously, then there would be a bigger issue. But it was still relatively quick. It was, I think, about 46 minutes, so less than an hour, which is kind of, impressive for them to get through all of that deliberation in a case with so much evidence.
Yeah, and there was, how many total counts, too?
10 counts total, so it's a lot to get through.
I think jurors, I think our experience has always been that they do take their job seriously. Even in, clear-cut cases, it's a serious matter with serious consequences for everybody involved. The defense, I think, made some arguments, not just for the murder charges, but some of the other charges in the indictment, too, that they probably worked through as well.
On the indictment itself, the defendant was charged with cruelty in the first degree, which is a malicious intent crime. But the judge did instruct the jurors that they could consider negligence as a lesser So cruelty in the second degree. So that was also something that they had to go through and decide whether what the act done in the presence of the children was malicious to the children or if it was just negligent. So I imagine that took a little time as well. It's a lot of law to break down.
Yeah. And talking about the defense, right? When you heard that the defense was being put forward by Mr. Norwood that, Crystal stabbed herself, walk us through what you made of that defense and what he was saying, because, to say that she stabbed herself 14 times is something that caught all of our attention.
Right. I knew from the beginning that was likely going to be something that he attempted to bring in front of a jury, because he was arrested about 4 hours after the 911 call. They found him relatively quickly. And when he was interviewed, for the first hour and a half of his interview, he stuck with a story that she had committed suicide, that she was suicidal, and that she did stab herself 14 times. And then ultimately came back and changed the story and said, never mind, it was me. But then at trial, he said that that was all because of manipulation, that he would have not said that had law enforcement not told him there was a video that didn't exist. But it was even worse at trial because the evidence showed that she was stabbed invasively 14 times, and then there were 2 additional incised wounds, or basically more than a scratch, but not a full slice. So a total of 16 wounds, including to the tips of her fingers, her knee, her face, places that no one is going to injure themselves in a suicide attempt. And then he started this new story on the stand where he said not only did she do this to herself to spite him, she also held his hand and said in her dying breath, "Take care of Nala," and that he was being a good Samaritan and helped her into the house, which was just even more absurd and more insulting. It was really hard to hear as the prosecutor, so I can't imagine how hard it was to hear as the family that was what he was trying to portray to a jury.
And just, he did all that after, obviously, that's after the state finished their case. The medical examiner already testified, and I think he explained why, in his opinion, he did not believe that they were self-inflicted wounds, and did a good job explaining the reasoning behind that. And sort of, especially when you look at the totality of all of the wounds together, that's just is not something that is, likely or probable. And so, the jury had already heard all of that before he got up and testified as well. And then Ms. Majors did an excellent job on cross-examination with the defendant. Even brought up we call it a ballistics dummy, but one where you can put in the rod showing where often bullet wounds are, but this was done to show where the stab wounds are, and kind of walk through all those with the defendant. And obviously the jury did not buy his explanation.
Hey, I just want to take a minute to thank the sponsor of this video, Aura. Now, did you know that your personal information can be collected by data brokers and sold, and that is completely legal in the United States? Oh, yeah. I'm talking your full name, your email, your home address, what type of car you drive, your relatives. It's all out there. It's all out there. I'm going to give you an example. Look at what happens. I'm going to do this right now. When I type in Jesse Weber, yikes. That is a lot of stuff, and I have absolutely no idea who's using it and how. Isn't that frightening? Well, these data brokers, what are they doing with it? They're selling your information to scammers, to spammers, anyone else who may want to target you. I know that's a frightening thought, but that is where Aura comes in, because Aura shows you which data brokers are selling your information and then automatically submits opt-out requests for you. Cleaning this information up not only helps reduce the amount of spam that someone gets, but it just protects from hackers who could use this information to help them access social media accounts, bank accounts, all this other kind of sensitive information. Aura does so much more to protect you and your family from online threats that you just can't see. And it is so easy to set up. You don't have to download several different apps to get things like parental controls, antivirus, VPN, password management, identity theft insurance, and so much more. I value my privacy. I value yours. You can go to aura.com/law&crime to start your 2-week free trial. You heard me right. 2-week free trial. And it's also linked below in the description. Check them out. I always imagine that a prosecutor having the opportunity to cross-examine a criminal defendant is something that you look forward to. What was it like cross-examining him? What kind of questions did you hit him with? Were there any surprise answers? Because unfortunately, we didn't have an opportunity to see it ourselves. So walk us through what that cross-examination was like.
It was wild. The things that he was coming up with, it was very clear that he had prepared what his defense was and the story he was sticking to, but he was not prepared to break away from that narrative. So once I was able to go in and throw back some of the things that he had previously said to law enforcement, and also brought up things that we observed in court and things that he had said on direct examination, he wasn't able to stay in this little I am the victim world that he had created. One of the most memorable moments, I think, from the cross-examination was that I was going through all of the fatal wounds. The medical examiner did say that 3 of the wounds to her body would have been independently fatal. And I walked through all of those to ask him, are you saying that Crystal stabbed herself here and would have likely bled out in 30 seconds, but continued to stab herself, and on from there. And I pointed out that one of the wounds was to her chest and had punctured her lung. And his response was, I don't think that's possible. And when I asked, what do you think is not possible? He said, well, that's not where your lungs are. And I said, you understand that your lungs are in your chest? And he looked at the jury and said, I'm not a medical doctor, which was just something
clearly, yeah.
I just never expected. He also described himself as a good Samaritan and a good church boy. There were just a lot of things that you just couldn't make up that he was trying to present.
Yeah, and Randy, you watching that, I mean, what was your perspective on it? I mean, at that point, I mean, a lot of times we cover cases, and when a defendant is facing some really tough cross-examination, during a part of it, I said, that's the case right there. And I wonder if you were thinking that, again, considering the jury came back with a verdict so quickly, did you think that cross-examination, or maybe even him on direct, was the final nail in the coffin for him?
Yeah, I mean, obviously, we thought the case was strong. The state's case without the defendant even get on the stand. But it didn't, as he's on the stand, it didn't appear to be helping him really. My observation in my role as DA, I'm watching Ms. Majors do this, and I think, you guys covering a lot of trials see all the work in court and how cross-examination does of defendants, which is not that common, obviously. But obviously, it was clear that Ms. Majors was well prepared before coming into court, and that's what makes a good cross-examination, is prepared ahead of time for all of that, because you don't know what the person's going to say. Obviously, the jury come back pretty quickly, kind of signals what their thoughts were. I think some of the combinations of where the injuries were just make it, if you're right-handed, stabbing yourself on the right side of your body, kind of under your arm, I think is it maybe possible, but it's so difficult to do with where some of those injuries would be, especially to her leg and to her back. And the medical examiner, again, he had said generally, usually medical examiners are testifying, they've done a ton of autopsies, is usually self-inflicted cutting wounds are, cutting your wrist and things like that. I mean, it is I'm not saying it's never happened, obviously, but stabbing yourself is just not a common thing whatsoever.
Yeah.
And he did say that it was anatomically possible for a person to have stabbed themselves in every spot, because she could reach it. Any human could reach those places, but it wasn't probable. And none of the wounds had characteristics of them being self-inflicted.
I think people look at this case and they say, the evidence from the medical examiner's report to the DNA on the shoe, and there was a lot more that was presented at trial. It's not surprising that he was convicted. What I think people are trying to understand is the why, the motive here. Why did this happen?
The evidence at trial was that the 2 of them were previously married. They were in a contentious relationship at the end of their marriage, which ended officially, they were separated in July of 2021. And this was after an incident where Crystal called 911 because the defendant had pointed a gun at her and their young child. Their child would have been an infant at that time. At that point in time, she left, got a temporary protective order against him, and filed for divorce. They were officially divorced in November of 2021. And in that time, he was ordered to pay child support. One of Crystal's best friends testified at trial and said that right after that hearing, Crystal had contacted her and said, Deonte told me that he will kill me before he ever pays me child support. And about 24 hours before her death, the defendant was served with a contempt letter saying that he was $5,000 behind in child support, and if he did not pay, that it was going to be increased $500 a month. All of his text messages in the days before this to Crystal were about child support. All of the communications that he was having with other people right before this, including with the woman he was dating at the time, were about child support. And even some of the children that regularly testified mentioned that they knew about child support. They actually called it child rent, which was heartbreaking to hear a child say. But that seems like it was it. He did not want to pay her child support, and this was his solution. He actually said on direct examination that he never intended to pay her child support.
Well, you know what's so sad about that? Unfortunately, we cover so many of the cases where that is the motive, and it's really disturbing to say. Now, listen, Randy McGinley, Lacey Majors, I know you say this isn't a win, but I will say again, congratulations. It is a win because you got a murderer off the streets and held accountable for what they did. Thank you so much for the work that you do. Thank you so much for coming here on Sidebar. And again, if you can, on behalf of all of us, please extend our well wishes to the family because this must be an incredibly difficult time. But thank you so much, both of you, coming on.
Thank you.
Yeah, thank you for having us.
All right, everybody, that is all we have for you right now here on Sidebar. Thank you so much for joining us, and please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.